Hello everyone, my name's Travis and this is Jack. Today we're going to talk about the second part of our Spotlight series on estate planning. In the first video that we released, we discussed topics surrounding probate, and in this one we're going to focus on wills. In the previous video, we did briefly talk about some of the aspects that are important to consider in a will, and we did just want to spend some time just reviewing those basics. So the first question is always, what is a will? Why is it important? A will is a legal document that allows individuals or a family to control what happens to their assets upon their death. When you are in the process of writing a will, one of the most important things that you need to consider is nominating an executor. And an executor is one or a couple different individuals that are responsible for a couple things. Number one, they will help pay your final, or they'll help file your final tax return, pay any sort of debts that you owe, and then at the end they're responsible for distributing your assets according to the wishes that you've laid out in your will. We often get asked, is there any sort of professional that we should use when we're writing a will? And there are. The two most common are a lawyer or a notary. And we always recommend that individuals speak with a lawyer. The main reason is a lawyer can provide legal advice. They're versed in estate law, and they can help guide you in writing the wishes in your will. A notary is mainly responsible for signing off on the document that you've created. Finally, the other thing we always suggest as a way to help make the life of the executor easier is a document that can summarize your affairs. And so we've created a document called the Executor Checklist. And really it's a document that allows you to indicate where your bank accounts or investments are. If you have utility bills that you pay online, what's the username and password, even things like social media accounts. It's important that it's easy for the executor to be able to close those down. And then finally, it's also really important to indicate where the most recent copy of your will is stored. So if the executor doesn't have this, it's a quick and easy way for them to be able to locate it. So Jack, what are other things that people need to consider when it comes to estate planning?
Okay, good question. So Travis talked about a will. This is a document that guides your wishes when you are gone, when you're dead. The other two documents that are important are power of attorney and healthcare director. So we'll get to that in a second. So once you've written your will, you need to sort of look at it every 3 to 5 years, dust it off, make sure nothing has changed, beneficiary designations are correct, there's no new grandchildren, make sure the executors are still available, they haven't moved away or something like that. If there's been a major change, marriage, divorce, death, significant change on the assets you have, then you would need to redo and write a new will. If you own shares of a private corporation, then you might also need a will for that. And that's again where a lawyer can help guide you. And the other documents, as I mentioned, the power of attorney and healthcare directive. These documents are for when you were alive but are unable to make decisions for yourself. Or with a power of attorney can be if you're traveling and something needs to be taken care of, you can give a power of attorney for a period of time. But for most people, it's more about what happens if you're unable to act on your behalf, perhaps dementia later in life. This grants a person known as the attorney the right to act on your behalf. and this person has a fiduciary duty to act in your best interest. Like the executor, this person should be organized, should be able to keep records. They want to be able to go back to other people in the family and say, here's what was done for mom or dad. Everything is nice and neat and organized. The healthcare directive gives someone the right to make decisions on your behalf if you're unable to make health decisions. So maybe it's long-term care, maybe it's something more serious when you're in palliative care or final days sort of thing. So again, it's a legal document that gives someone to make decisions on your behalf. All of these documents, wills, powers of attorney, and healthcare directives can only be written while you're mentally competent, while you're able to. They can't be changed if you're suffering from dementia or something. And so, as Travis says, we always recommend using a professional estate lawyer. They understand case laws, they see what happens to families when things go not as planned. Another thing that can be a good idea as part of the planning process is having a family meeting. This is especially useful if there's a lot of assets, or it's a large family, or it's complicated. This gives mom and dad a chance to explain their wishes. It gives a chance for family members to ask questions. They can explain where their estate director is, who to contact, who the advisors are, what phone numbers are important, where to find the will. Families will have different memories of what mom and dad really wanted. So, and that can cause problems. It's very emotional settling in the estate. And so if you have some notes on what they really wanted, that can help reduce some of that tension. Doesn't mean it's going to go away, but it can help reduce it. Another good idea for mom and dad to do is to say, here's our funeral wishes. And we often recommend that they prepay it. It just takes away one step at that initial step dealing with the loss of a parent. So that's always a good idea. Travis, let's talk about some examples we've seen over the last few years.
So I just talked about the importance of nominating an executor. And you can have instances where family dynamics are complicated, or the degree of difficulty in settling an estate is also large, and the parents may not feel comfortable nominating children or family members to look after their estate. We had an example just recently where there was complicated family dynamics. There were 7 beneficiaries, 7 siblings, and mom and dad were struggling as to who to nominate as an executor. In this particular instance, not all of the 7 siblings were financially savvy, and then to add an additional layer of complexity, one of the siblings was disabled. And in this particular instance, mom and dad wanted to provide a larger sum of money to the disabled individual relative to the other 6, and that had just caused some tension among some of the other siblings. So in this particular instance, we recommended that they speak, or that the parents nominate a third-party executor. This is a company that their sole job is to help manage the estate of families or individuals. By doing this, or the purpose of this recommendation is our concern, if mom and dad had nominated a family member, would be that the executor or the family member that had been nominated would be blamed for distributing out the assets that mom and dad had laid out in their will. And the third party executor was going to be a way of alleviating some of the tensions that the family may have throughout the estate process. Other questions that we commonly get asked is how to address young children or minors in your will. And there's a couple things that you'd want to consider. So in the event that your child or a minor is going to inherit a small sum of money, maybe it's a couple $100,
Maybe it's a grandchild.
Maybe it's a grandchild, yeah. The government, the government won't care if you decide just to pay that money out to the child. In the event though that it's a couple $1,000s or maybe tens of thousands of dollars, you're going to need to set up a trust, and you're going to have to nominate a trustee to look over, to look after the trust while that child is a minor. And then once the child becomes of age, which in BC is 19, that money can then transfer over into
To the child.
into the child, yeah. Where it can be really beneficial though to have rules in the trust is if it's a larger sum of money. So, perhaps $100,000 or more. And the parents may want to include rules in the trust, such as things like how the money can be spent, how much money they'll receive on an annual basis once they become the age of majority. We had actually just provided an example of this in our previous webinar, where mom and dad created a trust but didn't set rules once the child had become the age of majority, and the child spent the money quite quickly and later regretted that decision. Another important thing to consider is guardianship. So this is an individual that you would nominate in your will to help look after your children upon your death. So the guardian and the trustee and the individual that's managing the trust, they don't have to be the same person, and they can be, but they don't have to be. So for the guardian, you'd want an individual where their skill sets are more focused on being loving and nurturing and raising your children as you would see fit. And then you would also potentially want to ensure that the guardian is supported throughout the years that they're raising your children. So those could be rules that you'd want to put in the trust, or at least things to consider. In the previous example that I just talked about, one of the children was disabled. So again, in that particular instance, we had suggested that the family consider something called a Henson Trust, which is a trust that just helps the disabled individual continue to receive their government benefits. But trusts are fairly complicated financial strategies, and so we would always recommend that you communicate with a lawyer to help get direction on your best course of action.
Yeah, good. A couple of years ago, we had another situation. Client, early 50s, divorced, two children, 19 and 23 roughly. He died suddenly without a will. Son had seen him 1 week. Next week, tried to get a hold of him, was gone. Then, so they're dealing with that, and then they find that a woman has moved into his house and is claiming to be his common law spouse. If she was indeed a common law spouse, she would have been entitled to a significant part of his estate. Neither child had ever heard of this woman, and so they had to go and prove that she wasn't a common law spouse. It took them quite some time. It took them several months to get to the point where they were then to go back to the courts and petition the courts to be given the right to settle his estate. Very, difficult for the two young, the son and daughter. We were lucky that all we had for the client was an RESP, so that was fairly straightforward. But he'd come to Canada as a very young man, worked really, really hard building his business. And he was hoping to retire in a few years. He had significant real estate assets. He had a bit, and all of a sudden he's gone. And for his children, the other thing is he's not only put them through the stress of trying to deal with this other woman in his house and his loss, but now they're going to inherit all that work that they're going to benefit from all his hard work. And we go back to the concept of the previous example from last video, the young man inheriting everything at age 19 and going through it very quickly. So he's also put his children potentially in that difficult situation. Just to summarize, sort of 3 key points from today. Get professional advice. They know the lawyers, state lawyers know the case law, they know what families go through, they see things when it gets messy. Communicate with your family, let them know your wishes, help them as much as you can, especially on funeral plans and so forth. And then help your executor, make sure they've got all the tools they need to find everything. They don't know your life as you know yourself. You want to give them everything you can to help their lives and their job as easy as possible. So that's it for this video. In the next video, we want to talk about how we sort of incorporate some of the estate topics we brought up, how we make everything as easy as possible through our retirement planning, and then introduce a couple other strategies that can be used to help get the estate you want to where you want it to be, and reduce taxes as much as possible. So for now, I'm Jack.
And I'm Travis.
Thank you very much. Any questions, please give us a call.